Senator Sessions, when I was a small child, it was during World War II, and my father took me to a racetrack south of San Francisco called Tanforan, and it had become a detention camp for Japanese American citizens. And during the length of World War II, well, thousands of families were held in this compound. And we checked with CRS, who says no Japanese American was ever convicted of any sabotage against the United States during that period of time. Senator Lee, Senator Cruz, and I have tried together to enact a bill to assure that no American citizen or lawful permanent resident detained in the United States can be held indefinitely without charge or trial pursuant to authorization of military force. So here's the question. Do you believe that the government can, pursuant to a general authorization to use military force, indefinitely detain Americans in the United States without charge or trial?
Senator Feinstein, that's an important question. Classically, the answer is yes. Classically, if you captured a German soldier, they could be held until the war ended. That was done, I'm sure, at the Civil War and most wars since.
I'm talking about American.
So then the question is, we're in a war like we have now that's gone on multiple years, and I would think the principle of law certainly would appear to be valid, but as reality dawns on us, and wars might be even longer, you know, it's honest to discuss those issues. So I respect your willingness to think about that and what we should do. But in general, I do believe, as Senator Graham has argued forcefully and for many years, that we are in a war. And when members who, unlike the Japanese, who were never proven to be associated with a military regime like the Japanese government, these individuals would have to be proven to be connected to a designated enemy of the United States. So I probably explained more than I should, but that's basically the arguments and the issues we're facing. I respect your concerns, and I'm sure they will continue to be debated in the future.
Well, let me just say a few things about that. I've served on the Intelligence Committee for 15 years. I read all of it. I think I know as much as anybody about what's happening in the United States. And this is not, these are Americans that we're talking about. They can be picked up and detained and held without charge.
You're talking about Americans
of trial indefinitely. And that should not be the case.
Well, I understand your point, and a citizen of the United States has certain important rights. They cannot be abrogated. It is absolutely so. They cannot be detained without undergoing a habeas review, and the government surely has to prove that they are indeed connected sufficiently with an enemy action against the United States so they couldn't be detained. And
well, I appreciate that. Let me go on to another subject. You were one of 9 senators to vote against the Detainee Treatment Act of 2005. It prohibited the imposition of cruel, inhuman, or degrading treatment or punishment of any person in the custody or control of U.S. personnel. You also voted against an amendment sponsored by Senator McCain in the 2016 Defense Authorization Bill to limit interrogations to the techniques provided by the Army Field Manual, which does not include waterboarding. Do you agree that the CIA's former enhanced interrogation techniques, including waterboarding, are prohibited by this provision of law as now codified at 42 U.S.C. 2000 DD?
It does appear to be clear that the last act, the McCain Amendment, would prohibit waterboarding.
and you would enforce that?
I would force the law, yes.
Thank you very much. Now, my third question is, and this was in the Washington Post, a report last night that you failed to disclose to this committee and to the Office of Government Ethics subsurface rights to oil or other minerals on more than 600 acres in your home state, some of which, I gather, are adjacent to a federal wildlife preserve. Apparently, Alabama records, and this is a quote, show that the senator leased undivided mineral interests to Chief Capital, a Texas firm, in 2015. Do you, in fact, own these interests?
Senator Feinstein, I believe that's so. And the way it happened was that many years ago, at least 50 or more years ago, my family, ancestors, sold some land and reserved mineral rights. Later, there was a dam built on the river and a desire to take land that were going to be flooded and to add additional land for a duck preserve. And they negotiated, and the family sold land to the government and retained the mineral rights per the agreement. At least that's my understanding. So by an odd series of events, the properties fell to me. I've never reviewed the deeds. I've never known how much land is out there that I own mineral rights on, although oil companies are pretty good about making sure they contact real owners before they drill a well. So you're correct that we reported the income on my return as coming from the property that I own and the property where the oil well is. I did not note in that report specifically that it was all income because the blank said royalties, but maybe I'm there. So I would just say to you this. We absolutely had, this is something I've taken no affirmative action in. It's something I'm going to take affirmative action in. I have one of the simplest, clearest, fairest financial reports you can see. My assets and my wife's assets are almost entirely Vanguard funds and municipal bonds. I've owned no individual stocks because I want to be sure that I don't have conflicts of interest. I want to adhere to high standards. We're going to find out what we did or didn't do and correct it.
Good. Thank you.